Good morning, everyone, and welcome to this Right Hustle webinar on the off-payroll rules, also known as IR35. I am Claire Halley-Smith, a commercial lawyer here at Right Hustle, and I'm joined by Joanne Duck, who's an associate in our employment team. Along with other members of our teams, we've both been supporting clients with IR35 related queries for some time, and so wanted to share some information with you ahead of the change in law, now due in April 2021. For the purposes of transparency, I should say that for various reasons, this webinar is pre-recorded, and so we're not joining you live this morning. We have, though, received several questions since advertising the webinar, and so we'll address these along with some questions that we find come up regularly with our clients, either during the course of the session or at the end. And if, of course, if you've got any queries arising from this webinar, then please do get in touch with Joanne and I, and we'll come back to you. And our details will be displayed on the final slide. So the next slide shows what we'll talk about. So what IR35 means, when it applies, and how it may impact your business. Joanne will go through the employment status principles, following which we will look at status determination statements in a bit more detail. But before we launch into the slides, I'm sure you know that the legislation was due to come into effect in April this year, and it was the impact of COVID and its anticipated effect on the economy that led to its postponement for a further year. And there's been some discussion in various sectors as to the potential for it to be delayed again, and this was voted on in Parliament over the summer, but didn't go through. And so things as they stand at the moment, the law is due to change in April next year, with no indication that a further delay is likely. And perhaps particularly so because we now have a vaccine that's in circulation, and also because the government has confirmed the huge loss in not being able to recoup these taxes to date. So on the next slide, we look at what is IR35. As you may already know, that IR35 was intended to address perceived tax avoidance. And the idea was that individuals worked through intermediaries such as personal service companies, and these individuals were delivering services in order to evade paying income tax and national insurance contributions by the use of this intermediary company. So in the private sector, responsibility to make any determination of employment status currently falls to the intermediary company that the worker has set up. And this has led to the belief that these workers are simply not paying the taxes that they should be paying. This change in law came into force in the public sector in 2017, and it's only now catching up with the private sector. And when it does in April next year, it will be the client, so that's the entity for whom the worker is providing the services, who will be responsible to make the determination as to the worker's status. And the client is responsible for the determination whether or not it contracts directly with the worker or via an agency. So on the next slide, we can see that in general terms, there are 4 steps to consider in order to establish whether IR35 applies to an arrangement. And these are listed on the current slide. So the first 3 steps are relatively straightforward. The first is that the worker must personally perform the services to the client. The second is that the services must be provided via an intermediary. And it's useful to know that the intermediary will often be a personal service company. The third step is that the client must be medium or large, as defined within the legislation, and so must meet 2 of the 3 conditions referred to in step 3 of the current slide as to turnover, balance sheet, and number of employees. The 4th step is essentially the crux of the legislation, in that the client must determine whether the relationship between the client and the worker would be that of an employer-employee, were it not for the existence of the contractual arrangement with the worker's intermediary. And Joanne will go through the factors that need to be considered to address this step in detail a little later on. There's also a simplified test, which allows certain organisations to consider only their turnover in order to establish whether they are a medium or large client. And where this exceeds, or where the turnover exceeds 10 million, the rules will apply. So this simplified test excludes various organisational structures, such as companies, limited liability partnerships, and unregistered or overseas companies.
Claire, you've mentioned about medium and large clients being caught by the new rules. Are there any obligations on those businesses that are defined as small under the test in step 3 that you mentioned?
Yeah, so if you're a small client, obviously in the private sector, then you won't need to make the determination, and that will continue to sit with the intermediary set up by the worker as it does currently. You will have an obligation, though, if you're asked by the worker or the intermediary to confirm the size of the business to enable them to make their own determination. And then, of course, there's the potential for growth. So a small client may find that it later meets the conditions of step 3 and becomes a medium-sized client. If this occurs for 2 consecutive years, the rules must be applied from the start of the tax year following the end of the second financial year within which those conditions were met. So essentially, if you're meeting the conditions of a medium-sized client for 2 consecutive years, the following tax year, you need to comply with the rules. So if we move to the next slide, we can see that IR35 is likely to have a significant impact on your business, whether you're a client or whether you're an agency sourcing workers for a client. The new rules, as we said, will apply from April next year, and in many cases, liability will fall to the agency, as it will often be the agency who is the entity paying the worker or the intermediary, and it is therefore defined as the fee payer for the purposes of IR35. So it's the fee payer's responsibility to calculate the income from which the income tax and the national insurance contributions must be deducted, making those deductions and accounting to HMRC. So to give you some example scenarios, we'll look at the next slide. So in this slide, we can see that the client is, of course, at the top and is directly contracting with the intermediary, which is the personal service company or the PSC. And the PSC is then contracting with the worker. Under this scenario, the client is the fee payer and must therefore make the relevant deductions. The next scenario, in the next slide, you can see that there's an agency also in the chain who is contracting with both the client and also contracting with the PSC. And so although the agency will recover any sums it pays to the PSC under its contract with the client, the agency remains responsible for payments to the PSC and is therefore the fee payer under the legislation and responsible for the tax to be paid. It's important to note here that responsibility for the determination of payment of tax always sits with the client. This is known as a status determination, and it means that the client is effectively the default fee payer. In order for the client to pass fee payer status to the agency, the client must pass a valid determination to both the agency and the worker and to any other party in the chain. And we'll look later at what constitutes a valid status determination statement. The key point here is that if the client fails to complete this step appropriately, fee payer status will revert back to the client rather than sit with the agency or the intermediary. In the next slide, we look at determining who in the chain constitutes the client for the purposes of the legislation. And this, of course, is incredibly important and will no doubt be subject to further analysis once the law is in place. For the time being, at least, it seems that where an agency is sourcing workforce for an organisation to undertake a project that it intends to run and manage itself, that organisation will be the client under the legislation, and the agency will likely be the fee payer, as demonstrated in the previous slide. But where, for instance, an agency might engage workers for short-term projects which are being managed by the agency rather than managed by the client, it could be that the agency is then deemed the client under the legislation. And this certainly needs to be explored further, at which point we'll hopefully be able to give you a more definitive answer on this. So the following slide acts as a reminder, really. It's the 4th step, which is determining whether or not the off-payroll rules will apply in considering whether the worker would be considered an employee were it not for the existence of the intermediary. And Joanne will now cover this in detail. So over to you, Joanne. Thank you.
Thanks, Claire. So as Claire mentioned, I'm going to take you through the tests that are used to address employment status. So if we look at the next slide, I just wanted to mention that over recent years, lots of different types of working relationships have developed, and this has added complexity to an already grey and murky area of law that governs whether an individual should be classed as an employee, a worker, or finally as a self-employed consultant. The most recent and significant development muddying the waters is the gig economy. This term has evolved following the cases of Uber and Deliveroo, which you may be familiar with, as they attracted lots of media attention at the time, and they still do. And these cases considered employment status in detail. Arising out of all the confusion that was caused by these cases, several reviews have been launched to assess whether the law around employment status needs updating to reflect the modern working practices like the Uber and the Deliveroo arrangements, and ultimately to prevent exploitation of vulnerable workers or conversely exploitation of the tax system. But even after all of these reviews, in all honesty, there still isn't really a clear fit-for-purpose set of legal tests governing the three categories of individuals providing their services in the job market. And as I said, specifically, there are three categories: employees, workers, and self-employed contractors. For the purposes of this webinar, we are focusing on the difference between employees and self-employed contractors. However, for completeness, please remember that there is that third category of workers too. So how do we tell the difference? There are several definitions of what an employee actually is in law. However, as is often the case, the draftsmen have drafted the definition in a very abstract way. The Employment Rights Act 1996 contains the following definition of what an employee actually is. So this act states it's an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment, which is rather a circular definition because it hinges on what is a contract of employment. And again, the Employment Rights Act helps with this, as it defines a contract of employment as a contract of service or apprenticeship, whether express or implied, and if it is express, whether oral or in writing. Again, not really helpful because what is a contract of service and how does this differ from a contract for services? Helpfully or unhelpfully, the contract of service definition is not defined in statute. It's not written in a particular piece of law. So what it actually means has been left to the courts and tribunals to decide, and they have developed several tests. So looking at the next slide, I can go through what these potential tests are. So you'll often hear the term, when looking at employment status, the irreducible minimum. And what on earth does that mean? The courts and tribunals have held that the irreducible minimum are the three key factors that must be considered when considering if there is a contract of service in existence. And they are mutuality of obligation, which I'll cover in a second, personal service, again, I'll go through in a second, and control. But there are also other factors that are considered when assessing employment status, but the irreducible minimum are perhaps the key three. So the other factors are listed on the slide. So other activities, so whether the consultant can perform other activities, nature and length of engagement, pay and benefits, integration, facilities, financial risk, and what the actual parties have called themselves, so what description they've attached to the relationship. So I've just whizzed over all of those things, but I'll go through each one in detail now. But it's worth mentioning that the courts and tribunals won't focus on one particular thing or one particular test. They will look at the reality of the situation. They will see what's actually happening on the ground, taking all of the above factors into consideration to reach a final conclusion on employment status. And as I said, from an employment law perspective, the irreducible minimum are the three key factors that are considered. The test applied by HMRC to determine if an individual is subject to PAYE is similar to the employment law test, but it's not actually identical. HMRC places slightly more reliance on an unfettered right of substitution for there to be a contract for services, i.e. a self-employed relationship, as opposed to a contract of service, which is the employment relationship. The right of substitution is something that I will come on to later. It's also worth noting that HMRC's assessment of status is not binding on an employment tribunal or court. So rather unfairly, if HMRC assess someone as an employee for tax purposes, for employment law purposes, they could still actually be classed as a self-employed contractor or a worker, which would prevent them bringing certain employment-related claims, such as a claim for unfair dismissal. So that distinction, whilst it is slightly unfair, is still relevant, is still evident in the law. So moving on to the next slide, I'm going to talk through what some of these tests actually mean. So the first thing considered is mutuality of obligation. And this really is there an obligation on an employer to provide work to the individual? And is the individual obliged to accept that work if it's offered to them? And if those things exist, there is mutuality of obligation. The key question is, can the individual refuse to perform work offered? If they can refuse, they're more likely to be classed as self-employed. If they can't refuse without getting dismissed or sacked, they're likely to be an employee. A significant case in this area is the case of Carmichael and National Power 2000. In this case, two individuals received letters from a power station operator, which offered them what the power station termed as employment as station guides, just on a casual and as required basis. And whether it was actually employment was considered by the House of Lords eventually, and the House of Lords agreed with the Employment Tribunal that the letter given to the individuals did no more than provide a framework for a series of ad hoc contracts for services, so contracts for self-employment, where the parties could potentially refuse work. When they were not working as guides, they were not actually in employment. And the court found that the company was not promising to offer the individuals work, but was merely intimating that it might be offered at points in the future. And in the same way, the individuals were not agreeing to actually do the work. They were merely intimating that they were open to the invitation of work. And on that basis, the contract didn't create any mutuality of obligation and therefore could not be a contract of employment, but was rather a self-employed relationship, so a contract for services. Another test looked into by courts and tribunals is the personal service test. And other than in extremely limited and exceptional circumstances, an employee is required to provide personal service, i.e. do the job themselves, whereas a self-employed contractor can provide a substitute to perform the work, so they can subcontract it to someone else if they want to. And again, I'll give you a key case to sort of give some life to what I'm saying. So one of the key cases for the personal service test is the case of Pimlico Plumbers and Smith. And that's a recent test, it's 2017. Sorry, recent case. And this case considered whether plumbers were workers or independent contractors, and it reached the Court of Appeal. The Court of Appeal reviewed all the case law in this area and summarised the following principles. So the court held, if there is an unfettered right to provide a substitute, this is not consistent with the requirement to provide the services personally, i.e. do the job yourself, which is required in an employment or contract of service relationship, and therefore this would suggest self-employment. However, if there's a conditional right to provide a substitute, this could or could not be consistent with personal service. So in other words, whether the individual is classed as an employee or a self-employed contractor will depend on the precise contractual terms and the degree to which the right to send a substitute in the individual's place is limited. So the Court of Appeal gave some examples of limitation and the effect of those. So if there's a right to substitute only when the contractor is unable to carry out the work himself, this would lead towards an employment relationship, i.e. a contract of service, as this is suggesting in all but emergencies, the individual had to perform the work themselves, so personal service was required. Conversely, a right to send in a substitute that is limited only by the need to show that the substitute is actually qualified to perform the work, so that they are as qualified as the contractor, that would lean towards self-employment, i.e. a contract for services, because the individual has discretion to either do the job themselves or send in someone else as long as they're suitably qualified. Back to the other side of the fence again, the Court of Appeal said a right to substitute if only the consent of another person who has absolute and unqualified discretion to withhold that consent to the substitute would lead towards an employment relationship, because that's consistent with personal performance. There's too much control placed over that right of substitution for it to be an employment, for it to be a self-employment relationship. So I've touched on control. So moving to the next slide, we courts and tribunals will look at control as a factor, and it means what it says on the tin, really. Another important case here is the case of ready-mixed concrete and the Minister of Pensions and National Insurance. This is a really old case, 1968, and it was one of the earliest judicial decisions about employment status, which touches on the element of control. Now, I remember this case as being the Downton Abbey case, the Downton Abbey test arising from the case, because in the case it was said that control includes the power of deciding the thing to be done, the way in which it shall be done, the means to be employed in doing it, and the time when and the place where it shall be done. And it was made clear that all of these factors need to be considered together to determine whether one party has control to a sufficient degree for them to be classed as a master and the other to be classed as a servant subject to that master, hence the Downton Abbey reference. The terms master and servant, my Downton Abbey test, are outdated though, and it's now recognised that employees, particularly senior ones, apply their own skill or expertise without direct supervision by an employer. And in addition, there are situations where an independent contractor can be subject to a high level of control, but still actually be an independent contractor, particularly in the construction industry. So the control test now focuses on whether the open quotes employer has the right to direct what the individual does rather than precisely how they do it. Case law has stated that an employee engaged under a contract of service, i.e. an employee, would commonly be told their place of work, their working days, their working hours, and be subject to the employer's day-to-day direction, their rules and policies, and particularly in relation to their standards of work. Whereas a self-employed individual would usually have a greater degree of freedom in their method of working, so they could work more independently from the employer, be less likely to submit to the same controls or supervisions that an employee would have to submit to, and can determine their own working days and hours. And that leads nicely to other activities, which relates to exclusivity of service. Generally, an employer expects their employee to give them exclusivity of service. Therefore, if an individual is free to provide services to others, and in fact actually does so, this may be a sign of self-employment. And HMRC has also recognised this. So HMRC has cited that the number of businesses by whom an individual is engaged and his independence from any particular paymaster is a relevant factor in determining self-employment status for tax purposes. However, it's not as simple as that. So employers shouldn't place too much reliance, too much weight on this factor, because it can be misleading. Because, for example, it's perfectly feasible for a person to have more than one part-time position but still be an employee. So they could be employed by one company for 3 days of the week and be employed by another for 2 days of the week. Also, in the case of 0 hours contracts, exclusivity clauses are no longer enforceable, and individuals working under these type of arrangements must be allowed to carry out work for others. But noting, however, that if someone is engaged on a 0 hours contract, the law expressly states that exclusivity cannot play a factor in determining employment status. So in simple terms, what that means is just because there is no exclusivity clause in a 0 hours contract, this doesn't actually mean that the contract cannot be found to be an employment contract, which is important. Looking at the next slide, another thing that the courts and tribunals look at is the nature and the length of the particular engagement, which is sometimes relevant but not always. And the courts have found that a person engaged on a permanent basis, so there's no defined end date to the relationship, might be more likely to be considered as an employee than someone that is taken on for a specific task, where the engagement lasts as long as the task does. Also, it's commonly suggested that long periods working for one organisation or employer may be more likely to signal an employment relationship. But it's not determinative on its own, because it might simply be that the longer the relationship continues, the more likelihood there is of that relationship being challenged by the individual and tested by the courts, especially if it exceeds 2 years, because, as I touched on before, 2 years is the qualifying length of service that's required for someone who could potentially be an employee to bring certain claims against their potential employer, for example, an unfair dismissal claim. The other thing that is key in the status test is how is the individual paid and what benefits can they receive? So paying an individual through payroll and operating a pay-as-you-earn system is usually an indicator of employment status. However, a failure to operate a pay-as-you-earn system does not necessarily indicate that the individual is self-employed. Because, as you know, some people can be employees but are not subject to the pay-as-you-earn tax system. Generally speaking, the inclusion of a person in occupational benefit schemes, such as share option schemes, health insurance schemes, bonus schemes, all of those things tend to indicate employment status because it signals greater integration into the company and greater permanence of that relationship. Payment of statutory sick pay is slightly more tricky. It usually indicates employment status, but not always, because if an individual is classed as an employed earner for the purposes of national insurance contributions, they are technically treated as an employee for statutory sick pay purposes, even if they're not technically an employee for employment law purposes. An entitlement to holidays also a little complex, because individuals who qualify as workers, so remember I said there was that third category, as well as full-blown employees, have a statutory right to receive paid holiday under the working time regulations. So whilst looking at pay and benefits is helpful, it's not necessarily determinative of employment status. Looking now at integration on the next slide, courts look at the degree of integration into a business, because that can be indicative of employment status. Although in some industries, such as building construction, it's not really that useful as an indicator, because due to the nature of the work, a lot of integration has to occur. It can't be avoided. So courts would look at factors such as whether an individual carries out work similar to that performed by employees, whether they have line management responsibility for employees, whether they're included within the disciplinary and grievance procedures, whether they have access to occupational benefits schemes and bonus schemes like we just discussed, whether they have a company email address, whether they're in the internal telephone directory, whether they go to employment events or work social events. All of those things may suggest that they are integrated into the business and are more likely to be deemed an employee. On a similar vein, courts and tribunals look to see who provides the tools and the equipment necessary to perform the job. If that equipment is provided by the company, that's more likely to suggest an employment relationship. However, if the individual provides their own equipment, subject of course to exceptions like heavy machinery that are required in the construction sector, this is more likely to suggest a self-employed relationship. Two more tests to go through now. So the next one on the next slide, financial risk. An individual who bears the financial risk of a business is often in business on their own account and therefore a self-employed contractor. And also an individual who's paid per job or by commission only, or has the right to set their own rates, is also more likely to be an independent contractor. The great case, I love this case in the area, is the Court of Appeal case of Stringfellow Restaurants and Quashie, 2012. And in this case, the Court of Appeal agreed with the Employment Tribunal that a lap dancer at one of Stringfellow's nightclubs was not actually an employee and therefore couldn't pursue an unfair dismissal claim when Stringfellows wouldn't give her work. The most important factor considered was that Stringfellows was under no obligation to pay the lap dancer anything at all. She negotiated her own fees with her customers and risked being out of pocket on any given night if the fees or commissions that she owed to Stringfellows for allowing her to dance outweighed the fees that she actually earned from her customers. And in the court's view, it would be unusual to find that an employment relationship existed in this sort of case where the individual is paid exclusively by third parties and bears the economic risk of this arrangement. And finally, the courts would look at the description allocated to the arrangement by the parties themselves. As I said at the beginning of my section, the courts and tribunals look at the reality of the situation, however. So they look at what is actually happening on the ground to determine status using all of the tests that we've been through. So therefore, if the parties have labelled something a self-employed relationship when it is clearly an employment relationship, the label given is not decisive because it doesn't actually reflect what's going on. So in conclusion, you can see there is a considerable volume of case law on this subject. And despite recent reviews into the area, there is still no real simple hard and fast rules. Cases are strongly fact-based and outcomes are unpredictable. So one case necessarily wouldn't lend itself to another case, but there are some tentative conclusions that have arisen from the case law. And I'll go through these. So the first is that the irreducible minimum, what we spoke about at the start, so the mutuality of obligation, personal service control, they're unlikely to be the only relevant factors, but they're key factors. The courts and tribunals considering those key factors will, however, form an overall view, taking into account all of the tests and the factual circumstances. The second key conclusion is there needs to be a requirement for personal service for an employment relationship. However, simply including the right to provide a substitute in a contract will not in itself provide security of a self-employed relationship because limits on the right of substitution will be explored. An unfettered right to provide a substitute is suggestive of self-employed status. A conditional right could go either way. If the conditional right, so if it's limited only by a requirement to show that the substitute is actually qualified to perform the role, that would suggest self-employment status. However, if the right to substitute is limited in a greater way, that would lean towards employment status. The absence of mutuality of obligation is likely to be fatal to a finding that there is a contract of employment, so that is necessary really for an employment relationship. And where a person works under a series of short-term contracts, it is possible that each of those could be a separate contract of employment, even if they're short and temporary. So it may be necessary to assess the overall nature of the relationship between the parties to determine whether there is an overarching employment contract, sometimes we call that an umbrella contract, that exists due to the mutuality of obligations in between the periods of work. And finally, the degree of control exercised by an organisation over an individual is always a relevant factor.
Thanks, Joanne. Can I just go back to talking about exclusivity during an engagement? So can a self-employed consultancy arrangement contain an exclusivity provision for the duration of the engagement without this creating an employment relationship?
I've come across this question a few times, and it's actually a tricky one, because having an exclusivity clause within a self-employed consultancy agreement is not ideal, because its presence leads towards an employment relationship being formed. So by inserting an exclusivity clause, the client is essentially restricting the ability of the consultant from offering services to other people, to the masses, and that depicts an element of control and a restraint on the consultant's activities that is not akin to self-employment status. It's more suggestive of employment status. However, as I've just explained, the courts and tribunals review lots of factors. They look at lots of tests when assessing employment status. So an exclusivity clause on its own in a self-employed contract would not necessarily depict employment status, because the decision maker would review everything. They'd look at the whole variety of factors that we've just discussed. But nevertheless, in performing this review, the addition of the exclusivity clause in that contract is another marker on the employee side of the fence, as opposed to self-employed contractor side of the fence. So in summary, it's not fatal, but it's not ideal, and I would lean towards not putting exclusivity clauses in self-employed contracts. And if you do want to put one in there, I would exercise caution over doing that, and definitely seek advice from us before you do that as to how that should be worded.
Okay, great, thanks, Joanne. That's great. So if we go on to the next slide, we can see that a client must consider those principles that Joanne's just been through in order for it to make a valid status determination for each worker it engages, either through an agency or through an intermediary. And it must record its reasons for coming to that conclusion, which will then form part of the status determination statement. There is an HMRC tool called the CESS tool, and that stands for Check Employment Status for Tax. And there has been some criticism in that historically it hasn't fully considered all the relevant employment status principles, like the mutuality of obligations principle. However, it's used by HMRC in its assessments and can be used by both contractors and clients when considering whether or not the engagement falls within these off-payroll rules. So as well as making the status determination and recording its reasons, the final requirement is that the client must take reasonable care in coming to its conclusion. So how do you evidence reasonable care? Well, having a set of IR35 related internal processes will certainly help with this, as will having the documented reasons associated with each of the employment status principles, and ensuring that those staff undertaking these assessments have adequate training to enable them to do this. To labour the point, I guess, the responsibility for deducting income tax and national insurance contributions sits with the client until it has provided the worker and the agency and anyone else, any other party in the chain, with a valid status determination statement. And if it fails to meet its obligations in respect of this assessment, this statement, the fee payer status will remain with the client and it will continue to carry that tax liability. So on the next slide, we look at how the status determination statement should be presented. There's no specific format or method for it to be communicated to the various parties. The client must simply ensure that the worker is knowingly able to receive or access it. So although a template approach, we'd normally resist a template approach, having a specific formatted document would certainly guide those who need to make the assessment as to the relevant considerations, which Joanne's talked about. And this might then enable a consistent approach to be achieved for each worker. And also just to say that clients don't have to wait until April to do this. It can be done any time now up until April. So finally, on the final slide, following the 6th of April next year, once the status determination has been, the status determination statement has been issued to the worker and the agency, it can be challenged. And the agency or the worker can do this anytime up to when the final payment is received for the services. The client must respond within 45 days of receipt of any challenge, and during which time it should continue to manage the worker in accordance with its original determination. So 45 days isn't very long when you're faced with this type of challenge, especially when HMRC may require sight of how it was managed as well. So it's recommended that clients put in place a process for dealing with resistance to status determination statements. And this can include evidence of consideration of the reasons for the challenge and a record of the client's considerations in reaching a conclusion as to whether or not it deems the challenge correct or incorrect. So in terms of what clients could do, or what the parties should do, clients and agencies should do ahead of next April, it's really a case of reviewing all of your existing engagements. So for clients, this means that they will need to make a decision as to the employment status of each contractor, whether they're contracting directly with the intermediary for that contractor or whether they're contracting via an agency. The statement then needs to be provided to the worker and the agency. And as we've said, this can be done ahead of April in readiness for the change in law. Internal processes should be created to enable the management of the process of the IR35 status determinations and the management of any subsequent challenges. And for clients and agencies, you'll want to review your contracts to see where the tax liability sits in the various potential scenarios that you may find yourselves in, to ensure you're protected as far as possible from this and to make sure that the contract is IR35 compliant. And just to echo what Joanne was saying earlier, having an IR35 compliant contract is one thing, but the practical arrangement between the parties has to reflect this in order to avoid that liability. So now I think we've got to the end of our webinar. We've got some questions that were provided to us, which I'm going to run through just a couple of these with you that might be useful to you. The first one we got was a consultancy business sources workers to deliver services to its client via an intermediary. The client is located abroad. Who will be responsible for the status determination statement in the event the client based abroad refuses to consider? So in this scenario, HMRC will look to the next party in the chain to obtain the status determination statement, or it will look to the highest in the chain, which is located in the UK. So where the agency, or third party that would be the fee payer is offshore, the liability will move to the next party above them in that contractual chain, which is in the UK. And this could be the intermediary or the worker itself. There are some detailed examples on the HMRC website concerning companies based overseas, which might be useful to look at if you need further guidance on that point. Another one is if it is determined that an individual is an employee for tax purposes, will it automatically result in the same decision within an employment tribunal? And I think Joanne has touched on this point, and the answer is, strictly speaking, no. The IR35 rules only determine an individual's status for tax purposes. However, if it's determined that an individual is an employee for tax purposes, it's possible that the individual would also seek to establish that it's an employee under employment legislation, given the benefits that an employee is entitled to. So they might try to claim retrospective holiday pay, pension contributions, etc. And finally, another question which came in a little while ago is, a small company, an agency sources workers for two different clients in similar circumstances. Each client has taken a different view and provided conflicting statement determination statements. What are the options? So if we assume that each client has satisfied its obligations under the legislation with regards to the provision of a status determination statement. So it's taken reasonable care in coming to its conclusion and it's passed it to the relevant parties. The agency will likely be the fee payer and therefore responsible for making the required deductions. The agency submitting this question is required to act in accordance with the conclusion of the determination. But if the agency is concerned with the conclusion reached in either of the statements it's received, one option is to challenge the statement, as we discussed earlier. So if the agency disagrees with the conclusion, it can make representations to the client that it considers the conclusion to be incorrect, and it has 45 days within which, and once received, the client has 45 days within which to either reaffirm its conclusion or to provide a new status determination statement. And if it fails to do either of these things, the client will then become the fee payer. The other option, of course, is for the agency to seek to protect itself via the use of warranties and indemnities within its contract with the client. So I think it just remains for me to say thank you for listening to the webinar, and we'll update this when we have further information as to the forthcoming changes. We would be happy to hear your comments and feedback, and of course, please do get in contact with us if you have any queries you would like to discuss. And we look forward to the day, hopefully soon, when we can meet you again in person. Thank you.
Thank you.